Welcome to the Bringing the Human Back to Human Resources podcast. I'm Traci Chernoff, and I've spent my entire professional career in HR. Each week, we'll explore the delicate balance between people and business with the aim to reconnect the two and create meaningful outcomes. Listen in as I share my own experiences, challenge the status quo, and chat with guests from various industries about our mission to bring the human back to human resources. Hi, everyone. Welcome back to the Bringing the Human Back to Human Resources podcast and the Policy Pulse episode of this month. And we have some stuff on the agenda this week that is hot off the press, like as in the last 90 or so minutes, according to Bryan. So just a heads up, we're going to be talking about a couple of cases that we've kind of talked about a little bit, or we kind of alluded to some things that were coming down the pike. But just so you know, there's probably going to be more information that we'll be able to share as we learn more. But this is super, super, super new information. And we have a really interesting agenda. So we have two opinions on these couple of court cases that we'll share. And then we're also going to be talking about AI regulation in none other than the state of Texas, which is shocking in so many ways. So stay tuned for that. That'll be toward the end of the episode. But why don't we jump in, Bryan? Thank you again for being our Policy Pulse resident attorney expert and in all things HR and employment and all of that jazz. So with that, walk us through this Ames v. Ohio and what this whole opinion is kind of presenting within this court case.
So like you said, this one just dropped this morning, just within the last 90 minutes, 2 hours. We have touched on this one before, the Ames v. Ohio case. This was a white woman who was passed over for a couple of positions that were given to minority applicants internally. And she sued. It's not a legal term, but she sued essentially under the guise of reverse discrimination. And today, to get right to the point, today the Supreme Court unanimously decided that her case was valid, that the actions taken by her employer amounted to discrimination. Essentially, what the court has said, we can get into some more details, but essentially what the court has said is that nowhere in the statute from Congress back in, I don't know, whatever it was, 50 years ago, does it say that discrimination is illegal unless you're white, unless you're heterosexual, unless you're a male. Like, there are no disclaimers. It is discrimination. So that's why this is not necessarily a surprising outcome. But now we have it officially in our hands, and it settles some of the discrepancies between the circuits, because there were some circuits that were using this standard and other circuits that were not.
Wow. This is, I mean, I guess it isn't surprising, but part of me was a little surprised because it's not necessarily a case that someone maybe on the surface would think would be won, because so much of what we see from a litigation standpoint in terms of discrimination comes down to minority or marginalized groups, which of course women are part of that. But it's just interesting because I think it is fairly different compared to other cases that are out there, or at least other cases of discrimination that have kind of come up or have come across our desks, so to speak. But at the same time, I think it's really interesting in terms of why this matters to those of us in HR and what this kind of further validates for everyone, because to your point, there is this whole framework that didn't exist that you just pointed out, that it didn't exclude these other groups, and that discrimination can happen across these other groups, that discrimination can happen to anyone. So how does this impact HR and HR leaders?
Yeah, and essentially the terminology is that this is sort of a background circumstances. So the background circumstance is that this person is a member of a majority group, and so they have a higher burden to prove discrimination in the workplace. And that is what the court is saying is that's not legitimate.
Wow, interesting. Yeah.
So there's several takeaways, and one of them that I'll get to at the end is actually in a concurring opinion. But the big takeaway for HR, and this is something that you and I have talked about a lot, is apply equal standards across the board. All employees need to be treated the same and treated fairly. So there's no higher bar for a straight employee, a white employee, a male employee, whatever, to prove discrimination under Title VII. You simply apply the same discrimination standard regardless of the individual characteristics of the people involved in the situation. Aligned with that, we want to make sure that we're enforcing consistent policies and practices. We want to make sure that managers are being trained on how to spot potential discrimination and what to do when information like that comes up, whether it's from their own analysis or from another employee coming to them. This, from a business perspective, this is crucial to ensuring that the company has an adequate defense to any potential discrimination claims from employees. So the concurring opinion in this case was written by Justice Thomas, and he noted some concerns about an additional framework. So this is not concurring opinions don't change any laws. It's just basically a way for some one or more justices to say, "Hey, I think we should also address this." Just to essentially give people a heads up. It can also sometimes be a bit of a wink to advocacy groups saying, "Hey, find a case that matches what I'm talking about here. We'll take it and maybe rule in your favor." But essentially, there's actually from a Supreme Court case, I think back in the 80s, the McDonnell-Douglas framework is what it's called. It has three parts to it. The plaintiff, the person making the discrimination charge, must establish that there's evidence of discrimination. And that's usually a pretty low bar. It's pretty easy to, at least on its face, make that case. So then, assuming the plaintiff does that, the burden shifts to the employer to provide a legitimate business reason, a non-discriminatory reason for whatever employment action was taken. The plaintiff then has the opportunity to show that the stated reason, the reason the employer gave, was actually a pretext for discrimination or was just not credible. And so that is something that the concurring opinion with Justice Thomas said this should possibly also be on the chopping block, because it creates, not to the extent that the previous standard that was overturned today provided, but it's because this McDonnell-Douglas standard is not provided for in statute or in the Constitution. We know Justice Thomas is a strict textualist when it fits his agenda, that he thinks this should be on the chopping block because it is so similar to what they have just overturned today.
Interesting.
So I know that was a lot of nuance there, but so there is this additional standard that doesn't create the same level of burden for majority reverse discrimination plaintiffs, but it does still make things a little bit different. There's a little bit different level of the playing field. Interesting.
Thanks for walking us through that. I have a question. I have been of the belief, generally speaking, that proving that a company acted in a discriminatory way is actually kind of difficult to do in the context of, especially in a circumstance where a company is making a decision with proper protocols and, what's the term I'm looking for? Qualifiers. That said, you kind of shared that it's actually fairly easy for a plaintiff to come up with evidence that something could be discriminatory. Where maybe I'm understanding incorrectly, but is my thought wrong that it's actually much easier to prove discrimination, and then it's just a matter of the employer bearing that burden to prove that it's not?
So that's an excellent question, because it is difficult to prove discrimination. It is easy to show evidence of discrimination.
Oh,
and so
interesting.
That's the difference. So evidence of discrimination is you are a woman and you've been fired. Okay.
I see.
evidence
it's
of
basically easy to
potential
claim.
discrimination. Exactly.
Oh, okay.
And so like it can't be so outrageous like that there's 4 people that work at the company and you're the one who is fired because your position is the only one in the company that's not in sales and it's not generating revenue. So, and in an economic downturn, like that is a legitimate reason. So it probably wouldn't, that might be like an example of something that may not move past the first stage. But generally speaking, that first stage is fairly easy to show the possibility of discrimination. It's not the same level of burden for a court to rule in your favor. It's just saying, yeah, there's enough here that we should at least move forward.
Right. That the person could have a case saying that the employer acted in a discriminatory way. Interesting. I mean, I'm sure that there are listeners out there who, like myself, who are thinking, yeah, I've had employees say, you're discriminating against me. This is because I'm over the age of 40. This is because I'm a woman. This is because I'm a person of color, whatever that might be. 99% of the time, at least in my experience, there, you can never guarantee it, but there wasn't any discrimination necessarily in any instance of having that type of reaction. But obviously when employees feel scorned by a certain decision, they don't take it well, because sometimes most of the time, these types of decisions are very impactful on someone's livelihood and all of that jazz. That sometimes it feels like a threat to the company, and then the company either decides to move on from it, or they end up getting, I guess, sued potentially, or getting a strongly worded letter from an attorney that then proceeds to some other facet of that process. But what are your thoughts when people do ultimately, or maybe are at the end of, on the other end of a layoff, or being laid off, or have a decision that is negative in, generally speaking, toward their livelihood? They either lose their pay, or they don't get a promotion, or whatever it is. I should say, not lose their pay, they lose their job. When an employee reacts that way, saying, "Oh, it's because of this discriminatory thing," would you say that companies should be reacting a certain way, or is it still reasonable to say, hey, I'm an HR leader, I know that, obviously in our minds, we know that this decision was not discriminatory. We're just going to say, we're sorry that you feel that way. We want to support you, blah, 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 and move on.
I'll say a couple of things on that. And one of the things that I often tell clients is that we can't eliminate risk. We can understand risk and learn how to analyze it and prepare for it. And exactly to your point, that's kind of what HR is doing in that scenario that you just laid out. They're understanding what the potential risks are, and they're preparing for it. You can't eliminate it. You can't stop somebody from suing you. Going back to the discrimination specifically, it's important to remember that in order to hit that bar of proving discrimination, it has to be tied to a protected class, a protected category. So just being a woman who was fired is not necessarily discrimination. Being a woman who was fired because she is a woman is discrimination.
Right.
And I think that's a distinct difference. And to your point about, the emotion of layoffs, and it sucks. And, we're seeing a lot of that now, unfortunately. But to the emotion of it, a lot of people think like, well, I'm in a protected category and I was fired. And there may not necessarily be a connection there between the protected category and the termination itself. And that's where there's oftentimes a disconnect with people who unfortunately are part of a layoff or a termination. Right.
Yeah, that's helpful. I mean, I've heard it 12.5 times, probably more, when people do react that way. And I think you're right. You're ultimately doing a risk assessment, and you're like, well, is there any risk of litigation here? Is there something that we should be looking at differently? And I really think that most times when a company, when an HR person is at the helm of part, maybe not at the helm, but part of this decision making, that they're aware enough and mindful enough that there have to be, a set of protocols when making decisions like this, especially in mass layoffs, and especially if there are a number of people over the age of 40, all of that. What is the Older Workers something Act, OWPBA? Am I getting that right?
Yeah. Older Workers Benefits Protection Act.
Yes, yeah. BPA. Perfect. Yeah. That's like when, and if you don't know about this, look it up, but you have to do an assessment to see, do you have to report on to the employee being impacted, how many other people are part of that layoff. And especially if there are more than a certain number of people, kind of depends, I guess, on the amount of people being impacted, but how many people are over the age of 40, because then it's, it could be something that looks discriminatory, potentially, not always, but I know that that's one way that there are laws that protect people of a certain age, for example.
And it even applies outside of layoffs.
Right.
If you're over 40, if you're over 40, there are lots of things that sort of come into play, even if it's a single termination. Like, for example, you get extra time to review any severance packages. Yeah. You get time to revoke the package. So there's a lot of things that employers need to understand about with layoffs and even with single terminations, depending on the characteristics of the individual.
Right. Perfectly said. And it's a good reminder for everyone to know their rights. Know what you are owed. Moving right along onto our next case, where an opinion was also released just a little bit earlier. That is Catholic Charities v. Wisconsin, where the Catholic Charities of Wisconsin was denied a state unemployment tax exemption by the state Supreme Court, holding these particular Catholic charity activities that were primarily charitable and secular, not religious enough to qualify for the tax exemption. The Supreme Court of the United States unanimously overturned holding Catholic charities holding that they were entitled or are entitled to the tax exemption because it operated primarily for religious purposes. Do you want to walk us through that? Frankly, I'm actually surprised that anyone could decide that something is not religious enough when it's like a religious organization. It's like a funny thing to me, but I'm not an attorney. So.
Yeah. And so I have some publications in the last couple of months have asked me to write some articles on this. And I've always taken the approach that I'm not going to be surprised by this decision, that this is what the Supreme Court has said, but I disagree with it. And
interesting.
So, you laid it out perfectly. Essentially, Catholic Charities set up its own unemployment program for its employees that were terminated or laid off. And the state of Wisconsin said, you can't do that. We have a program in our state, and I think like 45 or 46 states do, and it's mandatory. And Catholic Charities said, no, we have a religious exemption because we're a religious organization.
Oh.
And the Wisconsin Supreme Court said, that's great, you're a religious organization, but the work that you do is non-religious. You feed, you feed and clothe people,
regardless of their background.
Right. Yeah. It's essentially it's essentially secular activities, right? So they are the Wisconsin Supreme Court said, this exemption doesn't apply because the activities themselves are not inherently religious. The Supreme Court today, again, unanimously has said, no, Wisconsin Supreme Court, that's incorrect. It's not the activities, it's the organization. So if the organization's mission and values is religious in nature, they can have this unemployment tax exemption.
Wow. Okay. Now I have a totally different perspective on this, because I'm thinking that, all of I guess I was thinking similarly that it's like based on the organization, but then I think about all of these celebrities that open up like their own charitable organizations and they have tax exempt status. And it's like, well, what are you, like, your organization could be, like there are celebrities who open churches, for example. I'm not going to name names because it's all allegedly they open up these these churches or different houses of worship, and then they have a tax exempt status, and God knows what happens under that status. It feels like maybe it's like one of those situations where two things can be true at once. Like the organization could be exempt because they are a religious organization, and the activities could still be tax liable. But I know that's not how it works.
Yeah, exactly. And the writing for the court, Justice Ketanji Brown Jackson said something similar to that the government needed to remain neutral and avoid distinctions based on theological differences when religious groups are providing these types of secular activities. And that's where they sort of leaned on that that churches, religious organizations can apply for and potentially receive these types of tax exemptions, specifically in this case, unemployment, if they are providing sort of charitable activities, regardless of the secularness of the activities themselves. It's because the organization is religious. I do think that this is going to have sort of we're going to see an exodus of religious organizations from state unemployment benefits, which is going to make that it's going to shrink the pool.
Yeah.
And to be clear, if you work for, I probably should have said this to begin with. If you work for a religious organization and you have an unemployment exemption in your state, that doesn't mean you are exempt from unemployment. You still have to have some sort of alternative system that at least meets your state standards so that your employees are taken care of when they're terminated or laid off. So it doesn't mean you can avoid unemployment tax altogether. There are some taxes religious organizations can avoid altogether, but this is not one of them.
Right. I have so many questions about this because, like, if one of their employees is terminated and then they need to file for unemployment, they have to file with their organization that terminated them. I could see a lot of issues with that.
Yeah, there are some organizations that manage this on a private basis for churches and religious organizations like this. So it may not be that you've got to, go back and talk to your boss necessarily or internal HR. It may be a vendor, a third party that you're dealing with, much like a state agency. But yes, Catholic Charities, if my memory is correct on the actual case, they do actually have an internal unemployment program. They don't outsource that.
Wow. This is really interesting. I'd be curious to see if anything comes of this. If, to your point, the pool shrinks and that does impact the other people outside of these particular organizations like Catholic Charities, who then would be eligible for unemployment insurance. I'd be curious to see if in these states where you can have this tax exemption as a religious organization, if that changes the benefit structure for everyone else because of the pool that's shrinking.
That's certainly a possibility because there's still the administration cost of doing it from the state perspective. But in theory, there would also be a reduction in the number of applicants. So a shrunken pool of applicants could match up with a shrunken pool of funds. But I also think you could end up seeing kind of like you were saying earlier, organizations that aren't necessarily religious have a religious mission, finding some way to get this exemption.
Because if for example, if the state has a minimum for the unemployment insurance percentage or the rate, I actually am not super familiar in the unemployment insurance and taxation category of things, but let's say the state, to your point, has this requirement for every organization, then you have an organization that is tax exempt from this, like Catholic Charities, that unemployment insurance amount changes obviously based on the amount that someone earns. Like if it's a percentage, then obviously that increases the pool. I could see organizations just adhering to the minimum, which then also could impact when someone in their organization is eligible then for that unemployment insurance. They're not going to get the maximum that they're allowed. They're going to get that minimum, whatever they contributed. And I don't know, I just see like that sure, it makes sense. It makes sense that someone, is eligible, they'll go to their organization, yada, yada, yada. But I don't know. I just, I could see like ramifications of this, whether it's bureaucracy and like not getting the response because there isn't the same level of accountability as there is at the state level. Not to say that they do it 100% correctly every time, but there is a very ironed out process in most states. It's just interesting. And then they have to like manage that process internally. It feels like such a waste of money for them to do that. But then it's like, well, are there advantages to having someone manage that versus that, that particular employee going through the state? I don't know. It's just very interesting. And I there probably are listeners out there who work for religious organizations or organizations that are exempt from this type of tax. So any words of advice for them?
Yeah, start with reviewing the org's mission and activities. This case has made it clear that it's not necessarily the activities that you're engaging in, the charitable activities, that are the determining factor of whether you can apply for and receive this unemployment exemption. It's whether your mission, whether you are inherently a religious organization. So you need to make sure that that's aligned. And then look at your current eligibility for the exemption under this new sort of standard, to see if you still qualify or if maybe you now do qualify. And then, like we talked about with the third-party vendors, look for alternative systems to outsource that burden, so it's not something that you have to shoulder internally.
Interesting. One final question for you on this, and I don't know if you know the answer. When an organization has a religious exemption, are there checks and balances that are executed at the government level, where it's like, oh, let's see how many employees you have on file. We've got to do an audit of X, Y, and Z. I ask that because I just wonder if bringing something like this internal could result in a lack of compliance with what's actually required at the state level.
It's possible that could happen. Yes. Generally speaking, so states manage their unemployment somewhat differently, depending on where you're located. So, but generally speaking, yes, the unemployment, essentially the internal unemployment systems have to roughly match what the state provides. But yeah, it's not the state providing it. So to your point, what happens if the company isn't managing it correctly or is paying below the minimum threshold for weekly, monthly benefits? That requires, to your point earlier, for people to know their rights. And that requires someone to not only know their rights, but also then have the time, effort, and energy to go to the state and say, hey, this employer is not managing their unemployment exemption correctly.
Interesting. Got it. Thank you very much for answering that. Yeah, know your rights, people. That's the best of that. That's probably going to be the title of this episode. Know your rights. It just keeps coming back to that. So now we have a few minutes left to talk about Texas and their AI regulation. Do you want to walk us through that?
Yeah. So the real short version of this is they have passed a new AI law. And yes, Texas somehow beat California to the punch on this.
Wild.
The bill, though, is the law is incredibly watered down. It doesn't take effect until January 1st of 26. It doesn't really even have much bite. The law itself just addresses something that's already illegal, and that's discrimination against protected classes. And as we talked about earlier, that's already illegal. So all this does is clarify that using AI is also illegal if it discriminates against protected classes. I think this is just my opinion. I think the law's intent as it was passed, originally it did have some teeth. But as it's been passed, I think it's just an appearance from the state to have regulation while avoiding significant burdens for employers.
Yeah, that makes sense. I mean, look, frankly, there have been over the last couple of weeks, there have been reports that have come out that companies that have been using particular AI-based or AI-driven recruiting tools specifically have have been sued for discrimination, and we can probably dig into some of those cases, but in a future Policy Pulse segment as they come up. But it's there's something here because we AI, it's very similar to social media. We saw this in the last 10 or 20 years where social media had no regulation. And frankly, there still isn't much of any regulation for social media, and there are ramifications to lack of regulation. And ultimately, the people who, or the impacted party when there's no regulation is generally an individual or group of individuals. And so while I am surprised that Texas was the first, effectively, very surprised, shocked, in fact, I think it will cause a ripple effect. Maybe not so much with the same breath, because I think California and New York and New Jersey and maybe even Massachusetts and a few other states will probably add some more bite to their regulation. There's something really important in this, that AI is an amazing advent in technology. It allows us to do so many things, and yet we have to have human intervention. Like there has to be, especially with recruiting, there's already discrimination in recruiting. So there has to be some level of auditing, checks and balances. Everything has to be set up in a way that ensures ensures that things are done fairly, equitably, and non-discriminatorily. And I just think about the really coming to recruitment and AI, like everything AI gives you what you ask of it. If you say we want someone with 15 years of experience, like fine, it'll give you those outputs. But if you don't also say that you want to have people from different backgrounds or with different educational experiences, you want to see, whatever those outputs might look like, you do run the risk of AI only giving you this one small segment or group of individuals, especially in the recruiting side of things. I don't personally have any experience with AI-based recruitment, but I can only imagine that in these companies where they're faced with lawsuits, effectively, that they just kind of offloaded that responsibility to the technology, which is negligent.
Exactly.
But
I agree with you. But in the 3 times, I think now in the last 2 or 3 years, the EEOC has said that sure, vendors can be liable, but if you as the employer are using AI software and that software discriminates against a candidate, an employee, whatever, you are liable.
Right.
You.
Right. And this comes back to
employer.
our last Policy Pulse episode. I think we talked about this too. And it's true. And it should be that way. The employer is liable.
Absolutely.
It's like just because you pay for an Amex Platinum doesn't mean that when your card is stolen, you get, Amex is responsible. Like, I mean, sure, they cover, there's fraud coverage and stuff like that. Maybe it's a bad example. But like at the end of the day, you are the benefactor. You are the person that is employing a vendor. And I think this is where it makes sense to me that vendors or AI technology or AI tools is not to blame here. It's how we as HR professionals, as business owners, use and embed this technology across everything. It's not even just recruitment, but really anything. Like there was that case, I don't know how many years ago at this point or not case, but the situation where attorneys were using ChatGPT. This must have been a couple, like when ChatGPT first came out, you probably know what I'm talking about. They used ChatGPT to look up case law and it was wrong. And then there was like a whole issue with this. I don't know all the details, but ChatGPT does not always get it right. You have to still have human intervention. And it's not just allegedly, it's not just ChatGPT. It's really any AI tool. And as we've talked about ad nauseum at this point, but it'll be interesting to see what other states kind of come to bat with AI regulations.
It will be. And I think that, like you said, there are some states that already have some AI legislation sort of working its way through their state houses that have actual teeth. My fear is that because there will be a discrepancy between state laws on some AI laws having teeth and some not, some regulation, some not. The Supreme Court is going to step in and
have something federal,
make a ruling on that to decide what is appropriate across the board. I do think that like your point about social media is spot on, and that is my sort of my doomsday approach. My doomsday thought is that we dropped the ball big time as a society on social media and the lack of regulation. And we did not learn our lesson. And we are going to do the same thing with AI.
Oh, interesting. You think it's going to be completely unregulated?
It's going to be because
it's too hard to regulate.
There's a lot of nuances to it for sure. But there's a push in the House, the U.S. House, not state, federal House, to pass a law that essentially places a moratorium on AI regulation for 10 years. Whoa. Meaning there can be no state law regulation of AI.
That would be wild.
I don't think it's got a big chance of passing. I think it's frankly more for show. But it's a non-zero chance that it passes, and that like we now have regulation that says you can't touch AI for a decade. And then, in a decade, we're all out of a job.
Wow. Yeah. Well, that's the risk, right? That's what I was thinking. I was like, what? It's so interesting. I mean, let's say that were the case. Can private companies still have AI policies then? I would assume so, right? Like if they said, oh, Absolutely. We don't put customer information, don't put proprietary information in, like you don't know who's on the receiving end of what you're putting in.
Absolutely. But if there's one thing in a capitalist society that I don't trust, and that is corporations to do the right thing.
Totally, yeah.
So
we need regulation.
Exactly. I mean,
look at social media. Yeah,
absolutely. That's the perfect example. We dropped the ball on that, and we're going to do the same thing here.
Interesting. Well, you heard it here first. Mark, I'm going to mark your words. You said it at the 36-minute mark. I can't let go of the social media thing because, frankly, I've said it before on the podcast that I feel like I have to be on social media because of my business, my podcast, whatever. And there's part of me that's like so anti-social media. I just don't want it because I feel like it's this like all-consuming thing, which is a big part of what kind of sparked discussions around regulation, especially social media for people under a certain age, kids, etc., and like what's allowed. And there were major issues with content moderation. There still continues to be issues with content moderation and what is allowed to exist. And then it brings up this whole topic of freedom of speech if you're in the US, but what if you're outside? Because you can be from Zimbabwe posting, and I could see that content here in New York. It's just one of those things. I can understand why there's no regulation, because it is kind of that runaway train that you create regulation and then there's something else and you have to create, right? And it's like, how do you manage that? And then obviously the social media creators, they have been notoriously anti-regulation, notoriously because some have changed their stance in some ways that allegedly. It's like then they don't want the regulation because that restricts what they're able to do, the money that they're able to make. I remember when Facebook first hit the stock market, everyone was like, Facebook's not going to make money. And Facebook's making money. And it's because there was no regulation. There is no regulation. And obviously social or digital advertising has become the major player in the last several years. So I agree, we dropped the ball. It'll be really interesting to see how the pendulum swings though, because I don't think I'm alone in this feeling of like, oh, social media sucks, even though you kind of have to be there in order to be in the know. And I just wonder how like generationally things will change. And then I say that and it's like, well, Gen Z is making their money on social media, so maybe it won't change. I don't know. It's crazy and wild.
It is. And it is. And I think that we're going to see a lot more tech advancement before we see any semblance of regulation in that space. I think it's just it. Yeah, I think we're just, laws generally, Congress generally is pretty slow to adapt, which is somewhat by design. But it's with something this complex with, I don't mean to make fun of most people in Congress, but like they don't understand how all of this works. And I'm not saying that I do either, but like they are generations removed from the creation of this type of stuff. And so for them to be the ones that are in charge of the regulation, I don't have much faith, I guess.
Yeah, it's really interesting. It'll be very interesting. What's another word for interesting? It'll be very
fascinating.
Curious. Fascinating. Yes, thank you. Interesting. Very fascinating to see how everything shakes out. I'm curious. Yeah. Well, look, at least we talk again next month, and maybe someone will hear this episode and say, we need to regulate social media. Psych. Well, in that case, Bryan, thank you so much for walking us through all this. I'm sure there's going to be more to talk about on the AI front, especially since Texas was the first to do it and California is probably cringing about that. So thank you again for your time, and always appreciate your expertise.
Of course. Thank you, Traci.
Hey, just before you go, don't forget to subscribe to the show so that you are the first to hear when an episode drops each week. And maybe leave a 5-star review and a comment about how much you loved this episode. Plus, if you have someone in mind who would really enjoy this episode, make sure you share it with them. Thank you so much for tuning in, and I will see you next week.